Behalf of the Firearms Policy Coalition, and I am very, very proud to bring you the Bruen Symposium. This is going to be a question and answer and a conversation about the Bruen decision, which protects the right to bear arms outside the home. Now, for those of you who do not know, FPC is your team fighting to create a world of maximum human liberty. FPC Law is the nation's first and largest public interest legal team focused on the right to keep and bear arms. You can support this legal team by going to, joinfpc.org. That's joinfpc.org. And you can also chip in a few bucks at firearmspolicy.org/donate. Now, before we get started, I want to let you know that if you have any questions after the symposium, you can go to bruinfaq.org. That's bruinfaq.org. After this video, and I believe this video will be posted there, and then we'll also have some frequently asked questions, and you can include your question there if you want to. Now, let's start with this. So the Supreme Court's Bruen decision is a landmark opinion with full support and holdings and implications on our Second Amendment rights. So we wanted to bring you the actual Second Amendment scholars and constitutional litigators to get some of their instant reactions. So with that today, we have a number of, very, 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 very important folks. We have with us Mr. Joseph Greenlee. We have with us Mr. Mark Smith. We have Erik Jaffe. And I am going to butcher Cody's last name, even though in the getting ready, he told me how to pronounce it. I'm going to give him a chance to go ahead and pronounce it for himself.
Wisniewski.
And I will say now the same exact thing I said in the pre-show, which was, I should have known that. So with that, out of respect, Mr. Wisniewski, I'll give you a chance to go ahead and introduce yourself first and let the folks know a little bit about who you are, and then maybe tell us a little bit about what you think about the case.
Absolutely. Thank you so much for having me. It's an honor to be here and to go first so that I can say everything novel before everybody else has a chance to weigh in. My name is Cody Wisniewski. I am the director of Mountain States Legal Foundation's Center to Keep and Bear Arms. We do national Second Amendment litigation. So we've been involved in cases from California to New York, everywhere in between. We did, in fact, file a brief in this case in New York State Rifle and Pistol Association v. Bruen. I know we're going to dig into it a bunch. So basically, my quick takeaway is that not only is this opinion going to be a landmark opinion for years to come, but it's actually somewhat beautiful in its simplicity. It doesn't really establish a new test or a new function, but rather reiterates the test that the Supreme Court established in DC v. Heller in 2008. And also restated in McDonald v. Chicago in 2010. So while it is certainly a landmark, it is really beautiful in Thomas's presentation and his analysis of the Supreme Court's existing test. Certainly, it is the first time that the Supreme Court has affirmatively stated that the right to keep and bear arms does, in fact, protect the right to bear arms outside the home, which seems like we probably could have gotten there before 2022, but this is where we are. And it also obviously strikes down New York's discretionary requirement in their permit licensing system, which will affect all other states with discretionary requirements in their permit licensing systems. But for the most part, this really just reiterates the fact that courts are to assess Second Amendment challenges based on the text of the Second Amendment as informed by history.
Phenomenal. Thank you so much. Thank you so much. And with that, why don't we go ahead and have Mr. Greenlee go next and kind of, once again, go ahead, Joseph, introduce yourself and let us know a little bit about yourself, and then give us your kind of initial thoughts on the decision.
Yes, well, thank you for having me. My name is Joseph Greenlee. I am FPC Law's Director of Constitutional Studies. We filed a couple briefs in this case. First, at the cert stage, asking the court to take on the case, and then again at the merit stage, asking the court, trying to influence the court's decision in deciding the case. Overall, I'm pleased with the opinion. I think this case went as well as we reasonably could have hoped for. I believe that the holding that ordinary people have a right to bear arms that may issue permitting schemes are unconstitutional, and that the two-part test is inappropriate for Second Amendment challenges was the best case scenario, given the makeup of the court. That said, I don't think the holding itself was surprising. It went the way a lot of people expected it to based on the oral arguments. And it really shouldn't be surprising that for a court to hold that the right of the people to keep and bear arms actually protects the right of the people to bear arms. I was glad that Justice Thomas drafted the opinion. He would have been, if it were up to me, it would have been my top choice to have him drafted, and he didn't disappoint. I thought the opinion was very well written, straightforward, easy to understand, and extremely well researched. And while I'm sure future courts will discover some things in there that I didn't notice yet, there seem to be fewer lines that can be taken out of context and used against the Second Amendment. That was the case with Heller. There were certain lines in there that have come to kind of swallow the Heller holding, and I think Justice Thomas may have had that in mind here. But overall, it was a very strong opinion, and I'm encouraged about what the future now holds.
I am no legal scholar as you are, but I would tend to agree with you wholeheartedly. And with that, Mr. Mark Smith, why don't we go ahead and have you step in next?
Hi, I'm Mark Smith, and I've always been a big fan of FPC, and I'm really grateful for all the wonderful work they do on behalf of the Second Amendment. So I really appreciate the honor of having me participate in this symposium. But for those of you who don't know me, I'm Mark Smith. I'm a constitutional attorney, member of the United States Supreme Court Bar. I've written several best-selling books, including on the Second Amendment. I'm also the host of the Four Boxes Diner YouTube channel, which talks about Second Amendment history and scholarly topics. I think there's really three things that stood out to me that may go overlooked in the press from today's decision in Bruen. The first is, this is clearly a 6-3 win for the Second Amendment and gun rights. And the reason why I say this is, although there were three concurrences, one by Justice Alito, one by Justice Kavanaugh with the support of Justice Roberts, and another by Justice Barrett, each one of those concurrences reaffirmed that they wholeheartedly and fully supported the court's opinion, which says unequivocally that the right to keep and to bear arms, to carry guns outside the home, is a fundamental constitutional right. That's the first thing. It's not any kind of a split decision here. It was wholeheartedly 6 votes in favor of the right to carry a gun outside the home in public in anticipation of self-defense needs. The second thing is the use of the phrase common use. Now, many of the people watching this are probably curious about what's coming down the pike next. And I think it's probably safe to say that the two issues that will next be decided by the Supreme Court, maybe not imminently, maybe in a year or two, it's hard to say, is bans on so-called assault weapons, which of course are just AR-15s. We've talked about this elsewhere, as well as bans on so-called large capacity magazines, which we all know are really just standard capacity magazines. The reason why I think this case, although it doesn't appear to address those issues, it actually does. Because if you read this decision, the court, again, this is 6 justices said this, that handguns, because they're commonly used, commonly possessed by Americans for lawful purposes, handguns are undeniably protected arms. And they embrace that test again. And if that test is applied to so-called large capacity magazines or so-called assault weapons, then those two will undeniably be deemed commonly possessed by Americans because they're owned by tens of millions of people. In fact, there's even studies out there that there's well over 100 million magazines that hold more than 10 rounds. And the last thing I just want to say that I think stands out about this case is, contrary to what the media is going to try to pretend to talk about, the media is undeniably going to be saying, this is a momentous decision. This is unbelievable. This is crazy. I can't believe this. This is unprecedented. But the truth is, it's actually not true. Think about it for a moment. As we sit here today in the United States, there are 43. That's 43 states out of 50. 43 states out of 50 allow you either in a shall issue regime or in a permitless carry regime to carry guns outside the home right now for self-defense. So we're really, in this case of Bruen, only talking about the 6 outlier exceptional states that are anti-gun. That's New York, that's New Jersey, That's California, that's Hawaii, that's Maryland, right? We're literally talking about a distinct minority of states in this great country that refuse to recognize the Second Amendment. And so the media is going to try to say this is an extraordinary change in the legal landscape of the United States. It's actually not true. It's really only addressing the 6 holdout outlier states that have been thumbing their nose at the Second Amendment for far too long. And I'm glad that the court is stepping in to fix it.
That is actually an excellent point. Excellent point. Okay, finally, Mr. Jaffee.
Hi, thanks for having me. Longtime fan, we've spoken before. I'm Erik Jaffe. I'm partner at Shaerr Jaffee. I've been doing firearms litigation for years. FPC is a longtime client of mine, as is the California Gun Rights Foundation, formerly called CalGuns, which I always liked better and thought was pithier, but there you go. And we had, my firm at least had 2 briefs in this case, one for the California Gun Rights Foundation. I think the other one was for Ted Cruz and company. So, we're very happy with the outcome, obviously. I couldn't be happier that Justice Thomas wrote the decision, given that I clerked for him. So, of course, I'm happy that he wrote it. I found a few things quite interesting about the opinion from the brief time I've had to study the lengthy series of opinions. First, I thought it was very useful to say that the presumption is that guns are protected, and the burden is on the states to prove a historical basis for regulating them, as opposed to the burden being on the individual to prove a historical basis for protecting them. That's going to end up being very important, that burden shifting. It answers a lot of the objections. It answers one of the concerns about lawyers being lousy at history. The answer is you don't have to be good at history. The only time history is going to justify a restriction on gun rights is when the history is fairly clear and likely overwhelming. Because if it's not clear and it's not overwhelming, you're not going to carry your burden. So it doesn't matter if lawyers are mediocre at finding every last statute. The answer is you need most statutes if you're going to try to justify some goofy restriction on guns. So that was the first thing I took away from it. I thought it was extremely valuable. The second thing I took away from it, which is sort of interesting, I guess, is whether or not this bodes ill for First Amendment balancing. Now, look, there's been a lot of criticism at the court about balancing in the free speech context as well, whether it's commercial speech, whether it's other types of speech, whether it's campaign finance. And the criticism here of balancing tests versus text and history, I think may very well carry its way into the First Amendment situation. And I find that fascinating, particularly coming from Justice Thomas, who has expressed some criticism for some of the potentially made up First Amendment doctrines, which, quite frankly, I like the made up doctrines, but recognize that perhaps they lack a certain historicity. And then the final thing I wanted to point out, just for a moment, is that there's still wiggle room for folks like the Ninth Circuit and the Second Circuit to wiggle. I thought there were discussions about analogous restrictions. Just like the gun didn't have to exist back then, neither does the restriction, but you should look to analogous restrictions that are done for analogous justifications. And I was a little worried that will give folks like the Ninth Circuit room to play fast and loose with what I otherwise think is a fairly clear, heavy burden. So I imagine we will still be fighting the Ninth Circuit sometime from now.
The Ninth Circuit playing fast and loose. I am shocked, I say, that could possibly happen.
Of course.
All right, so my first question is, all right, being a person who lives in one of those 6 states, 6 states and then Washington, D.C., or D.C., what exactly does this mean in a practical sense for us?
Well, if you're asking me as a DC resident, it means they're going to issue a lot more carry permits, is what it means. And so that's a good thing for folks who admittedly may be concerned with their safety. It's not like DC hasn't seen its share of crime over the years.
Yeah, I think there's going to be 2 things going on. I think, first of all, we already see, if you look at the quotes from the politicians in New York, of the anti-gun approach. So first of all, there will be more carry permits issued, is my guess. But the second thing is, how are the anti-gunners going to react, and how are they going to try to give the right but then take it away with the exception? And I think that what we've all been concerned about in the gun rights space is how the anti-gun states may use the notion of sensitive places. Now, sensitive places is a euphemism for gun-free zones. Now, if you look at the District of Columbia, it's actually quite interesting. DC has been a shall issue district for many years because of a case called Wren. It's actually shall issue. It's actually relatively straightforward to get a carry permit in DC right now because it's shall issue. The problem is that after they went to a shall issue permitting scene in the District of Columbia, they immediately went out and defined the entire city for all intents and purposes as a gun-free zone under the law. So crazily, in fact, that if you actually read the DC ordinances, and I guess Erik will probably know this better than anybody, it actually covers situations where if you're within 1,000 feet with your concealed carry permit and your gun, within 1,000 feet of a motorcade, you're a criminal. You can't even be within 1,000 feet of a motorcade. Now, I don't know how you figure out where the motorcade is going to be at any given moment of time. So I think that illustrates what's going to happen in these 6 states. They're going to try to give us the right with you have the right to carry, and they're going to try to take it away by defining as much of each state as a sensitive gun-free zone place, whether it be bars, restaurants, stadiums, homes, on and on and on. And I think that's where the next battle is going to be, is can you define entire states as sensitive places? And the Supreme Court actually said you can't, but trust me, the anti-gun states are certainly going to try, in my opinion.
Yeah, I agree with Mark on that. I think you're going to see a lot of arguments over sensitive places. You've already seen some statements come out of New York of them trying to designate places with more than, or looking at designating, I should say, places with more than 10,000 people as being sensitive in and of themselves. You have seen all their other states come out. So California's AG issued a statement where they said that their carry license is likely unconstitutional under Bruen, which I thought was refreshing coming from California. And I'm sure California attorneys in the California Department of Justice will come to hate that statement for years. But so you're going to see a lot of play with, yes, we're going to issue permits, but we're going to regulate where. One thing that Mark touched on that is really important in this context is that Justice Thomas goes to some length to talk about how you also define a sensitive place. He acknowledges New York's argument that they said, look, the entire island of Manhattan is a sensitive place because there's a lot of people and there are already police available to protect people. So there's no particular need there. And it's a sensitive location that's protected. And the Supreme Court rejected that argument, but also made sure to specify that sensitive places and the definition of a sensitive place also has to be grounded in text and history. And did a little bit of a proto-analysis on what might or might not qualify as a sensitive place. I think that you're going to see that be one of those sections that kind of Joseph about one of those sections that's probably going to come back to us in future years that we'll be arguing over. But that that distinction is going to be important, and relying on that language from Thomas on grounding sensitive places in history is going to be equally as important.
Wow. Excellent.
Looking at the historical traditions, there weren't many sensitive place laws, as Justice Thomas noted in the majority opinion. Typically, the only ones were at places like legislative assemblies and polling places and stuff that allowed the government to function. They didn't want people coming in arms and disrupting the way that government functioned. And there were a few instances, in the 1780s, for example, in Delaware, the different parties took turns kind of showing up at the polls armed and preventing the other party from voting. And then since it happened to the Whigs, then the Tories did it the next time. And so the Delaware Constitution, I think actually 1776 Constitution maybe, had a provision preventing arms at polling places, but they're very limited. And then they really didn't pick up until the late 19th century. So it's going to be difficult for them to find too many. They're certainly going to try to expand the definition of sensitive places and what areas. We're going to see all sorts of new places becoming sensitive. But I think historically it's going to be very difficult to justify. And we've seen a few examples. For example, Chicago had labeled anywhere 1,000 feet from a city park is sensitive, and the Chicago Supreme Court struck that down. The Illinois Supreme Court struck that down a few years ago, but I think we'll see more stuff like that where they're just trying to expand these sensitive places.
All right.
Yeah.
So
I wanted to just follow up on one thing that everyone has been saying about how are they going to get around this. I think the other thing that we should be worried about is they're going to start criminalizing all kinds of things because felons don't get to have arms. And so you will see a lot more felonies, and you may see enforcement of various felony laws against folks that they don't want to carry arms. So things that might have been a misdemeanor once upon a time will now become a felony. They'll just make it possible to get a year rather than unlikely. You'll also see red flag laws and mental health issues. They'll go after the people rather than the guns.
or they'll do like they did in California and start creating prohibiting misdemeanors.
And that brings up another interesting issue that's relevant to the holding here, because Justice Thomas, well, the majority, I should stop just saying Justice Thomas because it's the majority, the court opinion, held that two-part test is no longer valid, and courts need to look to text, as he put it, and FPC's been advocating for this for a long time, saying the test should be, and I believe Mr. Jaffee was involved in producing this, but the test should be text as informed by history and tradition, not just text, history, and tradition, because history and tradition are not on an equal field with the text. The text is central, and then you look at history and tradition to inform its original meaning. But anyway, Justice Thomas put it, text as informed by history today. I'm sorry, the court put it, text as informed by history today. And looking at prohibited persons, we've produced a great deal of research showing that it was not just felons or certain misdemeanors. It was only dangerous people with a propensity for violence who were likely to use firearms for illicit purposes, who were disarmed around the founding era, all the way up to about the 1930s, maybe even 1968, I think. So that's another questionable issue: are those bans on non-violent criminals going to be upheld any longer?
Well, you know, that you raise an interesting question. That was actually going to be my next question relating to the two-step approach. Can you just real quick, maybe someone tell us exactly what that quote unquote two-step process is, and then why is this change, as mentioned in the opinion, why is it so significant in terms of the analysis for future cases? You want to start with that one, Joseph?
Sure. So the two-part test was invented by Judge Sykes, actually, and later vacated opinion. I think it's called SCOTUS, although I've heard it pronounced like 6 different ways. But she invented this two-part test, which then, after that opinion was vacated, the Third Circuit and Marzarella adopted. And then by now, every circuit except for the Eighth Circuit has adopted this test. And so it was a controlling test. And the Eighth Circuit never really, they avoided adopting any kind of test. So it was a controlling test throughout the lower courts. But in part one of the two-part test, courts looked to the founding era, the original scope, or at least they were supposed to, and then they determined, does this law burden the original scope of the Second Amendment? And then if it did, then they move on to part two, and they apply heightened scrutiny, theoretically, intermediate scrutiny or strict scrutiny, because in Heller, they said rational basis, the other level, is not available for Second Amendment cases. This very quickly fell apart. First of all, courts never look anymore to, well, I shouldn't say never, virtually never look to the original understanding of the right in part one. They just say, well, we assume it's protected, and we move on to step two. And that fails to appreciate how deeply rooted in history and tradition some of these rights are that are now being taken away. And then the court jumps to part two, and it pretty much, like the Ninth Circuit puts it, does it further, would the government's objective be achieved less effectively absent the regulation? So if it does anything, if the regulation does anything to further the government's interest, then the law is upheld. So this has been devastating to Second Amendment rights. Virtually every law, I mean, the Ninth Circuit, to use as an example again, has upheld there's a few cases that are kind of in limbo right now, but the first 54 Second Amendment cases that heard it upheld every single restriction under this two-part test. It can be morphed into whatever the court wants it to be to uphold laws. So the court today, the Bruen court, said this test is no good. You can't use this in Second Amendment cases. You need to look to the text as informed by history. And so I think that creates a whole new kind of world for Second Amendment litigation. That opens up a lot of doors that had been closed and just evens the playing field for us who are the people trying to defend the Second Amendment.
Yeah, and I'd like to add something to what Joseph said, which is you read in the media, and I always talk about the media because a lot of Americans get their information from the media, and a lot of it, especially when it deals with the Second Amendment, is simply wrong. So you will read these comments that say that all of these Second Amendment cases have ruled against the plaintiffs who support Second Amendment rights. What they don't tell you, though, is where are these courts located and where are these laws based? You really don't see a lot of Second Amendment cases coming out of Texas or Oklahoma because you don't have a lot of gun control laws that are challengeable under the Second Amendment, places like that. So you have this skewed sample size of gun control laws being passed in the usual suspect jurisdictions of New York, of Hawaii, of Massachusetts, of California. And then you have these litigations, including this evolution of the two-part test that Joseph articulated quite nicely. You have these courts that have been full of judges who have been handpicked by people like Senator Chuck Schumer and Dianne Feinstein in California. They've been handpicked by these anti-gun senators, and now they sit on these courts in these blue states. So when these blue state gun control laws come up for challenge in front of these blue state-based courts, even the federal ones, lo and behold, they find an excuse to uphold them under the Constitution. So I think that this Supreme Court decision is made it very clear that even those anti-gun courts and those anti-gun states overseeing anti-gun legislation arising from those anti-gun states, it's going to be a lot harder for them to really rule in favor of the gun controlling states, because you're no longer, under this court opinion, allowed to engage in balancing tests where you say, well, how many people are killed with guns versus how many people are saved? The Supreme Court said today that's irrelevant. The only question is, what does the text say, and what does the history associated with that text mean? It has nothing to do with statistics or empirics or, faulty arguments about the good and the bad of guns. The Supreme Court made it clear that is not how to apply the Second Amendment going forward.
And the Supreme Court didn't just strike down the two-part test, right? The majority opinion eviscerates the two-part test to the point where, there's a quote in the opinion, the majority opinion as authored by Thomas, that basically says, one of the flaws of the two-step test is that there's one step too many. And so this isn't just a clear, look, we see that courts have been doing this. That's not okay. We really want them instead to do this. No, the majority opinion destroys the two-part test, says that, not only is it inappropriate for the protection of for the evaluation of constitutionally protected rights, which I do think might affect First Amendment, like Erik hinted at here, but also that there is no other consideration here but text as informed by history. The court even limited how far history is. I don't know that we can continue to say text, history, and tradition. I know that we talk about tradition as kind of the post-enactment history, but the majority opinion also limits the flow of that and how far it can go, or how far consideration should go into the future after ratification of the Second Amendment in 1791. So this is a clear smackdown of lower court's treatment of Heller since it was handed down in 2008, basically.
I like that. Smackdown. It was a smackdown.
I agree that it was a smackdown, though I am less optimistic that creative courts who oppose the Second Amendment will not find nuggets to play with here. And one can only hope that the court will not wait as long for its next case, when that starts happening, as it did for this case. As many of us on this chat probably have experienced many requests for the Supreme Court to review a case being denied. So I fully expect the Ninth Circuit to make great use of analogous restrictions to some past actual restriction. And their analogies, I imagine, will be strained, to say the least.
We saw some of that in the Kalchowski opinion from the Second Circuit. This was decided back when the courts would actually kind of apply the two-part test, so they would look in part one at the original understanding of the right, and that was a challenge to the same law, carry restriction in New York City. And the Second Circuit said, well, they pointed to a law, didn't actually explain it or why it was analogous. It didn't provide too much detail, but it was actually a law preventing people from firing off guns on New Year's Eve in the streets. And it said, look at that, like, guns in public have been restricted for a long time. And this is a founding era analog. And so I expect we'll see some creative interpretations of history like that, more so in the years to come.
We also saw that in Young, right, which just came out of the Ninth Circuit, which is technically pending before the Supreme Court still. So we saw the Ninth Circuit engage in this really bad historical analysis. And I think that's exactly what you're going to see. I mean, Joseph's right, Erik's right. You know, that's where you're going to start playing this he said, she said game, in that people are going to be throwing random historical statutes in place. New York tried to do it in this case, even, some of which was handily dealt with by the majority. But you're going to see this history battle, and you're going to see judges who want to find one way might, in fact, skew history in order to establish support for something that doesn't exist. The Supreme Court actually calls out the Young opinion a little bit in the majority analysis. So it'll be interesting to see what happens with that pending petition. I haven't seen if the orders have come out yet. I would expect that at minimum, they're going to, grant, vacate, and remand that case to be decided in light of what happened in Bruen. I think you're probably going to see that with all of those pending cases, which include Maryland assault weapons ban. It includes a New Jersey magazine ban. But we've seen what bad history looks like, and so we're ready for it. We know what to expect, but that doesn't mean it's going to be easy and it won't be an uphill battle. And waiting for another 14 or 12 years, depending on which case you're counting from, would certainly make that even harder.
Let me ask this question in relation to that. So the court expressly rejected interest balancing, like intermediate scrutiny or even strict scrutiny. What does that mean in terms of analyzing future Second Amendment court decisions?
Well, what it means is that instead of doing the balancing themselves, they will have to pretend that the framers or the framers' immediate predecessors did the balancing, came to some conclusion, and that their law balances the same interests in a roughly analogous way to come to the same conclusion. But you will see a lot of discussion, some historical, some ahistorical, about why different laws that previously existed were passed. You will see discussions of safe storage of gunpowder laws suddenly expanded and analogized to safe storage of guns. You'll see surety laws analogized to insurance laws. They will creep the balancing in, but they will have to go a step further by finding some historical precedent first and then expanding it through analogy.
Nobody is more cynical and skeptical of the acts of the anti-gunners than I am, but I'm a little bit more optimistic and hopefully not naively so about the future of the Second Amendment. We have to keep in mind that President Trump really did a fantastic job helping to reshape much of America's federal courts. The Supreme Court today, this decision today actually illustrates that point. Now, I'm not saying that the federal court system are all originalists the way it would be nice if they were, but the number of people that are more interested in the Second Amendment and interpreting it according to the way it's written and the history, I would say there's more of them out there than ever before in the federal court system. And I think just recently we saw this decision out there in I believe it was the Ninth Circuit, right, where you had the 18 to 20-year-old ruling that says that under the Second Amendment, 18 to 20-year-olds basically have a right to keep and bear arms, and you can't take it away from them. And that was the Ninth Circuit. So again, I understand they will be on bond and all this sort of thing, but I just think that we may be writing on a clean blank slate in a way that we haven't been in many, many years. And while I'm not saying that the Ninth Circuit and the Second Circuit and the usual suspect Fourth Circuit won't be doing terrible things to butcher the Second Amendment and its meaning, I just think it's going to be a lot harder for them to do it again, given this decision and the fact that the anti-gun community does not have a monopoly over the federal judges the way arguably they did, 10 years ago, because frankly of the successful work of President Trump and Mitch McConnell and Chuck Grassley in the U.S. Senate, helping to reshape the court system in a way that's much more favorable to originalism, which ultimately is good for the original meaning of the Second Amendment.
Well, having been involved in the bump stock litigation for a long time, I just want to push back on the notion that President Trump and his administration are actually that friendly to things like gun rights or anything like that. Yes, some of the lawyers who got put up there from the FedSoc are more originalist in their orientation, and that's a good thing, absolutely. And I agree with that. But plenty of folks, I think, in the lower courts still have a certain bent to them, like the Justice Department under Trump did when they decided willy-nilly to flip 100 years worth of rulings to ban bump stocks because, it scared them.
I think there's a little bit of a line between Mark and Erik that I'll probably take. And I really do think that we should be cautiously optimistic. We've been very worried, all of us, litigate in this space, file briefs in this space, to speak on this space regularly. We've seen a lot of bad laws coming down the pike. We've seen a lot of places not respecting people's right to possess arms, to carry arms, to defend themselves. But what we've also seen is a huge shift in favor of gun rights in a lot of places. Now more than ever, the dominant mode of regulating carry in the United States today is free carry. No permits, no state requirement. People can carry their arms. That is the dominant mode of regulation of carrying of firearms in public today. 40 years ago, there were places that still banned carry outright. I mean, I know that California and New York and Massachusetts kind of have functionally created zones where they ban carry, but there's no state that outright bans carry anymore. We're also now talking about a Supreme Court decision that is, for all intents and purposes, originalist. Another concept that was kind of an offshoot 40 years ago and is now the dominant mode of analysis for Second Amendment cases. Yes, we're going to have a lot of battles with history. Yes, we're going to deal with judges who are appointed by all presidents who are good at history or who are bad at history or who not seeing the right ties, the right analogies. But that's our job, is to try and convince them to see those appropriate analogies or to not see them where they don't exist. But we live in a country now where there is a huge shift in favor of gun rights. More people are allowed to carry or able to carry, than ever before. And we've got a court that's willing to analyze or at least prescribe analysis based on the text of the Constitution as it was understood when it was passed and ratified. I mean, that is something that we should all be excited about. And we've got a lot of work ahead of us, but I'm happy to work under that rubric as opposed to the two-step framework that we've been working under. So I think there is some market benefits here.
I think another reason to be optimistic is, as Mark had mentioned earlier, the Bruen opinion, they state at least 3, maybe even 4 times that reemphasize that the burden is on the government to prove that a regulation is constitutional. And historically, guns were not nearly as regulated as they are today, and it's going to be very difficult for them to do. If you looked at some of the amicus briefs that the anti-gun groups file to provide the historical regulations, they print out an appendix, and it's just a list of every regulation they've ever found, because they never have too many that are on point, but they're just like, look at all these, there's like 42 here, and they regulate something, so that probably justifies this. And so anyway, I think that's like a lot of things today, like building your own firearms for personal use was totally unregulated until just a few years ago. That's going to be very difficult for the government to justify restrictions on that. Bearing arms, as we saw today, and magazine capacity limits, that kind of stuff. There's just no historical justification for. So I think there's good reason. Of course, there's going to be a lot of opinions that were surprised at how far the court will go with their analogies and whatnot. But I think there's much more reason today to be optimistic than there was when we woke up today.
The Supreme Court held that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. Now, how should the courts decide that the plain text covers, and what does history suggest when we're talking about the scope of what that includes?
That's where you're going to see probably some of this historical finagling, right? You're going to see some circuits that are more favorable to the Second Amendment's protections are going to find that those protections are a lot broader. We've already seen circuits like the Ninth Circuit find that those protections are very limited. Under that two-step analysis, a lot of times when courts were going through and looking at the history, they would find that the core of the Second Amendment, if you will, was defined in Heller as, the right to possess a functional handgun in the home for the purpose of self-defense, which is just about as narrow as you could possibly read Heller, and is significantly more narrow than the Second Amendment's protections are. So you're going to see a lot of battle over the coming years on the breadth of the Second Amendment's protections. It's how it was understood in the founding era and what that should mean. So I think that's going to be one of the biggest history battles that we fight, in addition to this fight between analogous regulations that Joseph was just talking about.
I think that's an excellent point, but I think that it cannot be emphasized enough. And although I've never litigated these cases myself, I know there's some great attorneys on this call that have. And the reality is, the way these gun regulations and these gun control statutes were upheld was really quite simple. The government came in and says, guns kill people. Criminals use guns to do bad things. They use guns to do bad things to good people. We passed a law that, tries to stop that in the public interest, and therefore these laws are fine. And these courts have essentially rubber stamped them in the name of social sciences, empirics, statistics. And that's what it was. But Justice Thomas's opinion today for the court made it very clear that the courts are getting out, at least according to what the Supreme Court said, they're getting out of the business of weighing these economic, these statistical, these empirical pros and cons of gun control versus guns. They're getting out of that business, and they're simply about reading the language, interpreting it, and applying history to the extent you need to understand the text of the Second Amendment. And I think getting out of that business of empirics, getting out of that mathematical weighing of the interests between the state and the right is a huge advantage in favor of the gun rights movement in the United States. As to how big it is, we'll see. I should also note, the history, I always thought, and I'd be curious to see what you all think, I always thought that the best argument for the anti-gun community in terms of their history was in the Bruen case, where they had things like the English statute in Northampton. They had the surety laws in Massachusetts in the early 19th century. They had the bans in a couple southern states, antebellum of concealed carry, but not open carry. And they had, of course, the black codes that restricted all sorts of carrying of guns post-Civil War, basically thumbing the nose at the Freeman Act. So and you had the Wild West restrictions, arguably, in some of those territories. So I always thought when it came to anti-gun history, the best arguments, the best history in favor of the anti-gun community was the carriage arguments. And the Supreme Court basically just went right down the list and said, none of these are persuasive enough to uphold this law. I don't know how the anti-gunners are going to come up with better history in favor of the laws that they're going to try to uphold than what they had in this case. I'm not saying that judges are not going to, play around. I agree with Erik that a lot of these judges and courts are going to work overtime to draw, shall we say, skewed analogies and all that to try to do what they shouldn't do. They're going to try really hard. But I think, objectively speaking, it's going to be a lot harder going forward with these other gun control statutes that are going to be challenged than it was for Bruen. And the Supreme Court, really dismissed their better arguments. And I don't see any other case out there that had better history against our side than this case here.
Look, I agree with Mark. There's no question that this is a much better regime to be litigating under from the pro Second Amendment side. No question at all. It's at least 5 more arrows in my quiver, or I guess the better analogy is bullets in my chamber when I have to go fight back against these crazy laws that don't have any historical pedigree. I do see some historical pedigrees that are going to be interesting to see what happens with. For example, carrying to the terror of the people, right? Well, back in the day, people weren't that terrified by certain weapons, but they would be by others. Today, you walk around with an AR on your back, I bet you get a lot of people terrified. And so we'll see where they go, whether that's sufficiently analogous, not sufficiently analogous. I mean, I think some people will tell you they're terrified to see a 6-gun on somebody's hip. You know, whether that's enough, it's not going to be enough at the Supreme Court. The question is whether it's enough elsewhere. I'm also a little curious about Justice Roberts saying it's perfectly fine to have a licensing regime, because I don't recall a lot of licensing regimes back in colonial times. I mean, maybe I'm wrong and Joe can correct my history, but that wasn't a big thing. And yet he endorsed that in a seemingly ahistoric way. So I'm just sort of curious as to where it goes. But I think we do have far more arguments, strong arguments to make against those kinds of shenanigans.
Well, let me ask you this. So what do you think this ruling means for other cases, like bans of commonly owned firearms, like semi-automatic AR-15s or semi-automatic handguns, or, for example, California's handgun roster? What do you think this decision, well, first of all, do you believe it will potentially have an impact on these other issues? And if so, how?
I think I'm going to be busy in the next few years, as I'm sure all of us will be. I think there are some of these examples where we've already started to do the historical analysis, where we've already started to pull this out, right? We're talking a lot about how it's gonna play out in a courtroom or in front of a panel of 3 judges at a circuit or en banc, and what they're going to do to the history. But you've seen a lot of really good analysis into the laws that existed at the founding era. I mean, Joseph has done some fantastic work doing articles on analyses into the historical laws, along with Dave Kopel. They've done some together, some apart. But there's a lot of really good research out there that's very solid. One of Dave Kopel's and Joseph's articles was cited by the Supreme Court in this case, talking about sensitive places. I'm not sure if he's going to plug it, so I will for him. And so that was brilliantly done. You're going to see more of this come out. We filed briefs. So the Center Keep and Bear Arms, as well as Firearms Policy Coalition, we filed briefs in, like I talked about, the New Jersey magazine ban case, where we can show via history that the founders and framers were well aware of firearms that could fire more than 10 rounds without reloading. We could show that they were well aware of, firearms with proto magazines, and that none of those factored into their analysis, or rather, in factoring into their analysis, they still didn't deem fit to ban anything that could fire more than 10 rounds without reloading. So there is the history out there for that. We've seen the history same on dealing with some of these so-called assault weapons bans, on the protection of arms that were the most useful to civilians were also the arms that were most useful to militaries at the time. And that was obviously understood to be appropriate and even the purpose of the Second Amendment. So there is a lot of good history out there. There is a lot of good analysis out there. And it's going to be very difficult for anti-gun cities, states, and gun control advocates to work around this history that demonstrates a broad protection of individuals' rights to keep and bear arms for lawful purposes. And those purposes include not just self-defense, but also defense of nation and defense against tyranny, which are very clear in the historical record.
I agree. In fact, there was an interesting line a couple lines in the majority opinion talking about when he's talking about handgun laws and some of the historical hostility towards handguns. One of the comments was there was a hostility to it because handguns were thought to be not useful for military purposes, which is why there was a hostility towards them, which is incredibly useful once you start litigating ARs. When people, the whole weapons of war exception from Heller that seems to have been closed off now, right? Heller had this line that says, of course, this doesn't include weapons of war. And, the anti-gun folks have ran with that. But I think the better reading of that part of Heller is about weapons that are useful exclusively for wartime purposes, like hand grenades, but perhaps not to weapons that have dual use. And so I think this opinion supports that reading of it, and it will be very useful for future litigation on things like ARs and semi-automatic weapons.
You know, to be clear, I think we should have never gotten to this place with ARs to begin with. Heller made very clear that arms in common use are protected and cannot be banned. And as Mark said earlier, ARs are owned by tens of millions of Americans. So it's pretty outrageous we got here to begin with, but I think it'll be especially difficult for them to hold up these bans going forward. And even if they look to the history, repeating arms go back to 1490 at least. The state of the art weapon at the time of the Second Amendment's ratification was the Girardani. There's different pronunciations, but rifle it was an air rifle, but they took it on the Lewis and Clark expedition. I'm pointing behind me but that's what that map is. But they took it on there and would hunt elk and stuff with it. I mean, it was a very powerful weapon, and relatively anyway, and to other air rifles, to be clear. But anyway, these magazine capacities, they had the Girardani had over 22 rounds it held. And so anyway, these repeating weapons and magazines capable of holding more than 10 rounds, a Kalthoff repeater goes back to, I think, the 16th century. And these things were not foreign to the founders. They weren't something you often hear. The founders could have never envisioned weapons like these. They certainly could have. The weapons were not all that different. And another thing that just occurred to me, this isn't very well thought out, but few things that I say are, a lot of the courts, I was saying before, how with the two-part test, back when they would even consider part one, they knew they were going to uphold the law under intermediate scrutiny in part two. So in part one, they'd say, yeah, this burdens the Second Amendment, and then they'd go on to part two and uphold the law. It'll be interesting to see how those same laws, now that part two is one step too many, as the court said, it'll be interesting to see what the courts do with their previous holdings saying, yes, this law does burden the Second Amendment, before they move on to upheld it under intermediate scrutiny.
And, it's worth noting that this decision actually does cite to the decision 2016 by the Supreme Court in Caetano versus Massachusetts. And you all know in that decision, the Supreme Court found that stun guns, of which maybe there's 200,000 of them in the United States, stun guns are protected arms under the Second Amendment. And if stun guns are protected arms under the Second Amendment and they're owned by only a few 100,000 people, then by the principles of a for Shaerr, if it's true for the lesser, it's true for the greater. Certainly AR-15s and large capacity magazines, standard capacity magazines really, would also be protected. And I do think it's telling that this court did cite to Caetano in the majority opinion written by Clarence Thomas.
Interesting. So,
yeah, I think it's an excellent point. And I absolutely agree that the endorsement of the Caetano opinion, which was a separate Alito opinion, is very important, because that's a useful test. It's an important test, and to see it confirmed at the Supreme Court level is valuable. It raises a couple interesting questions, of course. So body armor, I know some of the history talks about arms, including things like armor, and you see some states trying to ban body armor. Body armor is obviously not that usual. It's pretty unusual. It's not clear to me that it's dangerous, but let's wait and see what they have to say.
hey,
Erik, if it's unusual for you, we certainly run in different circles. But I think even in the Heller opinion, when you're talking about body armor, right, they look to the definition of arms from dictionaries surrounding the ratification of the Second Amendment. And the definition included weapons of offense and tools of defense. And Joseph can correct me if I'm defining it wrong, or somebody can. But it is clear that arms in 1791 did not just mean offensive weapons. It also meant tools of defense. And that was really important. And that still is really important. And again, another history battle that we're going to have to hash out in courts, and certainly more work for lawyers and whatnot. But it is another really important kind of fact, arrow in our quiver, if you will.
But it's interesting. The history on body armor is actually, I think, very favorable for those that want to argue that body armor is protected by the Second Amendment. First of all, I just want to alert you to a decision by district court judge in D.C., Trevor McFadden, a few months ago in one of the January 6th cases, where a woman from Texas She was a florist. I'm forgetting her name now. I think it was Cuddy, Cuddy, but you can check it out. She was convicted of a misdemeanor for trespassing in the Capitol, just a misdemeanor. And the Department of Justice tried to take away her right to bear arms for the 60 days that she was going to be on probation. And in that case, Judge McFadden, a Trump appointee, by the way, issued a ruling that said that he wasn't going to do it. And the reason why this is significant to the body armor debate is one of the big arguments that the Department of Justice made as to why she was a danger is that she wore a body armor style sweatshirt to the Capitol on January 6th. And Judge McFadden says, no, wearing body armor is not a sign of attack or offensive. It's actually a sign that you're worried about preserving your life. It's a defensive tool, which is, of course, consistent. And Cody made a good point here. It's entirely consistent with Samuel Johnson, the leading lexicographer in England at the time of the founding, who defined arms to be both offensive in nature as well as defensive in nature. And if you go back all the way to the Statute of Northampton, I can't believe we're going to talk about that again, although, but the Statute of Northampton, they drew a distinction really between being allowed to wear chainmail, which is the fine chainmail that you would wear under your tunic or your clothes. That was perfectly fine because it didn't scare anyone. But if you rode through the streets in this massive, jousting night looking, like you're getting ready for a joust in front of the Henry VIII, and you went through with all that big armor, that would terrorize the people. So there's already history in English history to protect really body armor, which I think is a very strong case. And I think that'd be a good case to take to challenge some of these laws. I think the history is very strong in protecting body armor as an arm under the Second Amendment. I think it'd be very interesting for one of you lawyers to take one of those cases. I think it'd be fascinating. I think you would win.
I think if we saw someone wrote strolling down the street in plate mail, yeah, that would be a little scary. Hey, we have some questions from some of our supporters that I wanted to kind of run by you guys as well. This first one was actually one that I had is, what effect do you believe this decision will have, if any, on interstate carry permit reciprocity?
It's got to help, right? I mean, it's got to help. It may take a couple cases to get there, but given that very few states, including the anti-states, are going to have an effective restriction on carry permits, I assume there'll be a process saying, hi, I have a permit in Oklahoma, I'd like a permit in New York, and maybe you can do that by mail. I mean, who knows? But it'll certainly make it easier for that to happen, it seems to me, or easier for us to strike down restrictions.
Well, there is Supreme Court precedent on the books that you have a right to travel. And these cases came out of the welfare cases several decades ago, where people would move from one state to another state and they would apply for welfare benefits. And a lot of the states said, no, you can't apply for welfare benefits in your new state until you've lived here for 6 months or a year. And the U.S. Supreme Court itself says, no, you have a constitutional right to travel from state to state as an American. So if you take those precedents and you combine it with today's decision, I do think there's a pretty good argument right now that, well, you don't give up your Second Amendment rights just because you cross into a different state. So I would think there is a stronger constitutional argument than ever before that we, under the Second Amendment, should be allowed to carry our guns under the Second Amendment from state to state to state, no different than you'd be able to drive a car. And again, there is a fundamental right to travel based on Supreme Court precedent right now.
One thing I've never really understood with reciprocity is I understand in some sense why a pro-gun state would, in retaliation, not recognize permits from a more anti-gun state. So let's just Texas and New York for ease of use. So New York obviously wouldn't recognize a Texas permit because it's New York. But then Texas in turn would refuse to recognize a New York permit as this kind of you won't recognize ours, we won't recognize yours. It would seem to me that you would want as many people with carry permits being able to carry in your state as possible. And if somebody had managed to get a permit from New York, you would want to allow them to carry in your state. So I think you might see that shift, and you're going to see more permit holders. I mean, that is going to be a necessary outcome of this decision, even if those 6 states and if DC writes their law, it's currently enjoined, as Mark said. 7 states, even if they rewrite their laws and still put barriers into effect, and they have delays and they have time to make decisions, whatnot, there will necessarily be more carry permit holders. And if more states recognize those, then that's a net win for everybody. That means there are more people that are in public, ready and able to defend themselves and to defend others.
You're making sense, and unfortunately, being in the state of California, our gun laws and nor do our politicians really make sense. So you got to kind of factor that in terms of some of these decisions.
I'm not really set for a career in politics. Law worked for now.
All right, here's another question. Are local law enforcement agencies still able to require interviews, range time, classes, and or weapon qualifications at the range in order to issue a CCW? But I want to add to that, what's the likelihood that we could see these requirements becoming much more onerous?
I think the short answer for anyone listening is you have to assume for the moment that those laws are still enforceable. I wouldn't be so foolish as to violate them. We may challenge them eventually. Folks like FPC Law will help challenge those laws if they're onerous. But I think you can certainly expect there to be more of that. I think you can expect there to be efforts at imposing insurance requirements, certainly training. They'll find some historical analogs for those, I think, not completely frivolously. It's just the expansion that will be somewhat frivolous. But the analogs, there was plenty of training in arms in colonial times to help, right, for the whole point of having a well-regulated militia. People needed to train. So I don't think you'll have a hard time finding some historical analogy to that.
And Justice Kavanaugh wrote separately, along with Chief Justice Roberts, to make the point that these schemes are okay when they require fingerprinting, a background check, mental health record check, and training in firearms handling. So I imagine those will be still be around for the states that, there's a trend where their legislatures are getting rid of those requirements anyway. Or not getting rid of, but saying you don't need to go through all that. You don't need a permit at all to carry. I think we're up to half the states now. But I do expect that those would be upheld, consistent with Bruen, that they will be, and that we will see some states implement these very restrictive, onerous, like you want to carry in New York, you need to train as much as a police officer or something outrageous like that. I mean, I hope we don't, and I think they'll be struck down, but I wouldn't be surprised if we saw a few jurisdictions get out.
We've been talking about the sort of the 6 or the 7 anti-gun states, which is rights. But, let's talk a little bit about what this decision means for the 43 other states where you're already allowed to carry either under a shall issue regime or a permitless regime or both. I think that the fact this decision came out, it's going to cause more states that are already sympathetic to the right to keep and bear arms to actually continue to move in a more favorable gun-friendly way. I think you'll see more and more states going to permitless carry on the grounds that the Supreme Court says it's a fundamental right. I think there'll be continued, excellent points that have been made here about, further recognition and reciprocity between the various states. So we always talk about what are the 6 bad gun states are going to do, and that's what we should be doing. But we also have to keep in mind that this also could serve as a major impetus for the continuing and ongoing expansion of gun rights in the already sympathetic gun states. We can talk about the Overton window growing, and I think this decision did grow the Overton window even further in favor of gun rights, in addition to the trends we've been seeing really since at least 2020, when people turned on the TV and saw rioting in the streets and law enforcement and government really not stepping up to do their job. People noticed that in 2020. We see that from gun sales, and now you have this decision. I think it's just going to encourage more and more states to enact more gun-friendly laws. And I think you'll see a lot more permitless carry states over the next few years than you have even today.
I agree exactly. I think there's one little perverse consequence of all this. I think pro-gun states, the majority of states, will actually become more and more lenient. I absolutely agree. But I think folks like us may push even their lines at some point. Because there are lots of laws that even pro-gun states generally like at the behest of law enforcement, whether it's serial numbers, what have you. We've seen this in the Cornelia case, where cops love to go in and take your guns when they take you for evaluation. They want to take your guns away from you. And so at some point, I'm curious to see what the point is. But at some point, we may find our former allied states, pro-gun states, suddenly saying, whoa, 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 we didn't mean you could do that. Even though this test in Bruen seems to be more expansive and would strike down a lot of other restrictions, notwithstanding Robert's concurrence.
I think one place you have that actually is, Erik, something you already mentioned, which is this felon in possession prohibition, which isn't really a felon in possession prohibition, right? So federal law prohibits anyone that is convicted of a crime that bears more than 1 year's imprisonment from possessing a firearm for life. And so that includes misdemeanors. And what a lot of people don't realize is that also means if you never spend a single day in jail, but the crime that you're convicted of is punishable by more than 1 year's imprisonment, you still are prohibited. So that's not a felon in possession law, right? That's a vast majority of peaceable people that are also being prohibited under federal law. It's something that a lot of, more pro-gun states some pro-gun states, I should say, tend to support because they view it as prohibiting dangerous people. But there have been a series of cases on this that came up at the beginning of last year. We at the Center Keeping Firearms filed a bunch of briefs. FPC filed some briefs and did some of the cases and has done some more work on it. I mean, these prohibitions have been applied to somebody a woman who lied on her taxes. It was applied to a gentleman who was convicted of illegally and illicitly importing cassette tapes in 1987. So these are broad, far-reaching laws. And so I think that will be one of those key areas as you start to get into this question of permitting too, because people who are prohibited persons are generally prohibited from having a permit to carry a firearm because they're also prohibited from owning a firearm. And so I think you'll see that come up in a lot of those more, what we would generally consider to be more gun-friendly jurisdictions.
Okay. Moving on to our next question. How long do you think it will take for states to be forced to issue permits? Any takers?
If you actually, it's a great question. If you actually look at what happened in the Seventh Circuit, which is out of Chicago in the Moore versus Magdagen case, there, as I recall, Illinois had no carry whatsoever at the time. And the Seventh Circuit Court of Appeals, the federal court out there, held that you have a right to carry firearms, you have a right to carry guns. And they entered an order saying that you have to allow people to carry guns. Then they entered an order that says that the state legislature of Illinois had 180 days to create a permitting scheme or decide what to do in terms of allowing Illinois citizens, residents to carry guns, and basically said, if you don't come up with your own system, that's fine. We're just going to basically go with a permitless carry system pursuant to the court order. And I think on the last day of the legislative term, on the 180th day, they actually issued an order, or I should say the legislature passed a law creating their current carry regime. So I think what's going to happen now is the Supreme Court sends this case back down. It's going to go back down to the district court in New York, and the district court's going to enjoin this law formally. And I suspect they're going to give New York, my guess is, some amount of time to kind of make their laws conform to the Constitution. You could arguably just enjoin this one aspect of the law and keep the rest of it in place, and it would be fine. But, I'm sure New York is going to try to be proactive in some way. So I don't think, as to how long it will take, it's hard to say. But there will be a lot of, civil resistance by these states when that court order comes out and joining, that aspect of New York's law from the district court.
I think that's a good point. In a number of cases, like in California, where it's actually up to the law enforcement agency, many of them are simply going to claim we don't have the apparatus to issue all these permits. Because in Los Angeles, there's like 200 in a city of how many million people?
Right.
It's going to raise big questions, big questions. Well, hey, I think that's going to be about it for the symposium. But what I would like to do is if there's any particular points that we didn't cover or things that you guys would like to share, I'd like to give you a chance to do that. Why don't we go ahead and we'll go in the reverse order in which we started so that I believe, Mr. Jaffe, I believe that puts you up first.
I guess the only thing I'd close with is it's nice to see this new and less arbitrary mode of analysis, whatever the problems that we may still face. It's a great thing to see. I'm curious and admittedly a little worried about how this plays out in other constitutional rights. I do more than just the Second Amendment. I do the First Amendment, and this could go funny ways there. But overall, I'm looking forward to the many, many challenges, to the many, many gun laws that are still out there under this new mode of analysis, because I think those challenges will be more likely to be successful now than they were just a year ago.
Excellent. Your thoughts, Mr. Smith?
Well, there are people in the United States, unfortunately, that want to convert Americans from being citizens into serfs or subjects. And one of the ways to do that, of course, is to disarm us so that we have to go mother may I to the government, to stay alive and for our, the necessities of living, including for self-defense. And I'm happy to see a very powerful and well reasoned 6-3 decision by the Supreme Court that reminds Americans, including those that don't really want us to be citizens, that we are still citizens. The Constitution still has meaning, and no matter how much they control the media and the universities and the public health schools and many of the largest corporations, despite all of that, there is still an understanding, at least in parts of this country, of the importance of the rule of law, the Bill of Rights, and the Second Amendment. And in that way, I'm very happy about that glimmer of hope for those that still believe Americans and the United States is a constitutional system, and we are still citizens and not subjects or serfs.
Excellent.
I just want to make sure that. Oh, I'm sorry, I jumped the gun there a little bit. Well, I just want to thank our supporters in the pro-gun community and make sure that they are aware of their role, really in this Bruen decision. The outlook on carry 40 years ago. I mean, it wasn't until Florida, I think, in maybe 1987, moved to shall issue. And then other states, of course, everyone went nuts, the media and politicians, that it's going to be the Wild West, all the same thing, that you hear these days. And then state by state, they moved to shall issue. And then now we have half the states in constitutional carry where you don't even need a permit. And it's because everyday freedom-loving Americans demanded that their representatives allow them to carry guns. I hate to use the word allow there, but previously many of them couldn't. And now we have this great decision from the Supreme Court where every American has the right, and we wouldn't have, I don't know that we have Heller or Bruen or McDonald for that matter, without the environment that the gun culture has created, making this an accepted and celebrated part of our lives, again, as it was at the founding of our country. And so I just want to thank everyone for their role in this and make sure they know how important they are.
You're up, Cody.
All right. Oh, you aren't going to go with my last name?
Wisniewski? Yes. I could say I got your last name, Wisniewski.
I think one thing that we've kind of walked around that we haven't talked about and that is incredibly important here is that this opinion, this majority opinion from the Supreme Court, recognizes yet again the existence of the natural right here, the pre-existing right. Your right to protect your life, to protect yourself, your loved ones, and your property, your right to protect your nation from tyranny, that doesn't derive from the Constitution. It doesn't derive from the Bill of Rights. That derives from your nature as a human being. You have the right to protect that life. And the Supreme Court here signs off yet again on that understanding of rights, on that pre-existing right. And so I think it's really important that we recognize that, and that when we're talking about these issues, we recognize that these rights are protected by the Second Amendment. They're not derivative from it. And yet again, the Supreme Court has endorsed that view, has signed off on it, has recognized that. And it is something that we need to continue hammering home, and it's something that will never change. It's wonderful that we have a constitution that is set up to protect us. It's wonderful that we have a Bill of Rights that is designed to explicitly protect certain rights, but those rights are ours. And if we haven't given them up explicitly, then they remain ours today.
That is actually an excellent point. You know, the thing that's frustrating to me when I see this is that it requires us. First of all, I'm so happy for the system of government that we have, where we don't just have a despot or a body of despots in a legislature that control our fundamental rights, but we actually have a body that we can go to where we can seek some redress. And you know, I just want to tell you, the ability to be able to go to court, to be able to sue, to be able to stand up and actually talk about the rule of law and human rights and fundamental rights in the defense of in the defense or in opposition to some of these laws, I think is vitally important. That's why I want to encourage you. You know, my end has always been on the legislative end. I've always been an advocate before the legislature, but I am a big believer that the big way in which we defend our rights, protect our rights, has to do with the courts. And that's the reason why the Firearms Policy Coalition, that's why we have our hotline, our 2ahotline.com, where if you feel that your Second Amendment rights are being violated or they are in jeopardy, they've been placed in jeopardy, you can at least reach out to an entity or group that is actually interested in standing up for those rights. We can't take every case. We don't take every case, but we do stand up and we do take the cases that can make a difference, not just for you, but can make a difference for all people when it comes to the right to keep and bear arms. And if you want to hear about or you want to read about some of those cases, some of those lawsuits, all you have to do is go to fpclegal.org. That's fpclegal.org. That's where you can read about all of the cases where we are involved, the ones in which we're litigants, but also the ones in which we've filed friend of the court briefs. It's vitally important that you know about these cases because some of these cases are going to be affected by the Bruen decision today. Now, I saved some of these things for the very end because I really didn't want to interrupt the conversation and the flow that was going on. But here's the thing, folks. FPC is an organization. It's a membership organization, and we're only able to do what we do. We're only able to support these fine attorneys with your support. So I want to encourage you, if you're not already a member, please become a member today. Go to joinfpc.org. That's joinfpc.org. Go to You want to become a member of the Firearms Policy Coalition, so make sure that you guys get there. And finally, if you are a member and you don't just want to donate, by the way, you can donate by going to firearmspolicy.org/donate. But hey, you can also go to FPC Gear. It's fpcgear.com. It is the place to go and get all of your Pro 2A swag. And the best part about it is every dollar that's spent here goes right back into the fight for our right to keep and bear arms. So you can support the Second Amendment and you can look good doing it. That's fpcgear.com. All right, folks. Hey, gentlemen, I just want to thank you for what I consider to be a master class on Bruen. Once again, I want to remind folks, if you watch this and you still have questions, please go to Bruen, BRUEN, FAQ.org. That's BruenFAQ.org. There'll be other frequently asked questions there, or you can submit a question and we'll see if we can get an answer for you. Once again, gentlemen, thank you so very much for being a part of this symposium. And I hope to have you one morning on Coffee with Craig to kind of talk a little bit more detail about some of the other work that you're doing relating to firearms. Who knows, maybe even about this case.
Thanks for having us.
Thank you.
Thanks, Craig.
Thank you.
All right, gentlemen. Well, that's going to be it. Once again, thank you so much for tuning in. Please remember, this is a fight for our civil rights. If you want to use them, you got to use them or you're going to lose them. You guys take care.
If you like our videos, follow, subscribe, like, and share.